Early in your career, what was your biggest misconception about how disputes actually unfolded?
Early in my career, I used to believe that the disputes are all about legal merits. The side which has better legal arguments will be the side which will win. Experience corrected that very quickly.
In recent multi-million dollar arbitration matter that you led, what is a single strategic decision that shaped the entire matter?
So I believe the single most important strategic decision was that we chose to build internal coherence before we pursued external aggression.
We will talking about the next 10 years. What is the biggest mindset shift in-house legal teams must make to remain relevant?
The relevance would lie when the in-house counsel is able to point out the crisis early on.
Where do the disputes really begin? Is it in contracts, in emails, in operational pressures, or marketing or sales targets or leadership decisions?
See, disputes begin when
Hello everyone. Welcome to another brand new episode of Due Diligence with Rahul. Our today's guest is Mr. Vipul Dingra. He's a legal counsel for a world-renowned MNC company. But before that, he was a litigating lawyer who started his practice 2 decades back in New Delhi. I'm going to request Vipul to give a rundown to his professional career, as only he can give us insights on how his role has evolved over the period of last multiple years that he has been spending with this world-renowned company. Then before that, where he was working with some of the biggest names in industries from India to UK to multiple countries and locations to talk about. So welcome, Mr. Vipul, to our show.
Thank you very much. Thanks for having me here.
Thank you. As I suggested, I would want you to give us insights on your role and your professional career and how it has evolved to the current role today.
Absolutely. So, as you already covered, I'm from Delhi. I started my career as a practicing lawyer in Delhi. Started in courtrooms, arguing about the matters for my clients, primarily around the civil matters, injunction, property, and all those things that the usual lawyers work about. And I worked there for about 3.5 years before deciding to move in-house, which was not a very usual thing to do at that point in time, which it has become now. And I transitioned over to a legal outsourcing company, handling their global contract management, working on large-scale commercial transactions. And then I decided to go further deep into it when I moved into a security services industry, working for a world-leading MNC in that area. It's a listed MNC. I started handling their legal matters across Asia and Middle East jurisdiction. Lived in Middle East for a while as well, and gained some exposure about the regulatory and compliance aspect around Middle Eastern and Asian jurisdictions. Before I decided to move to Mumbai and call it my home and start working for an OFSC provider, again, one of the top four in the globally. And now I'm handling their legal work across Asia jurisdiction, working on arbitration matters, dispute solutions, otherwise labor union issues, commercial transactions, contract management, and compliance matters as well.
If you don't mind, can you share the name of the company?
Yeah, sure. I'm working for Weatherford. It's a US-based listed MNC.
Nice. So, Vipul, in our conversations, you happen to mention, you are very humble, by the way, in your description of your role. But I know the magnitude and size of the territory you cover.
Yeah.
And how many countries? I think 5 or 6 countries you mentioned. Can you give us
So right now I'm supporting legal operations for India, Thailand, Myanmar, Philippines, Australia, PNG, and New Zealand.
So East Asia through and through, I think, till New Zealand you cover.
From India till the most eastern side it can get.
Wow. Vipul, you move from litigation from New Delhi to legal outsourcing and then into oil and gas industry, which is very intense and has global implications on many things that happen. How did this transition has sharpened your different dimensions of your legal judgment? Can you give us some insights on it?
Sure. I mean, see, I think it's very obvious. I mean, so given you move across jurisdictions, you move across industries, each phase sharpens a different muscle, right? You start with litigation, you learn about discipline, you very quickly get to know that the courts don't award anything based on the drama part of it, right? What the judges reward chronology, consistency, document credibility. That's what the judges are looking at.
Very true.
You very quickly get to know that you need to be prepared when you are approaching the court. But the downside of it is that when you approach the court, things have already happened, right? You're only controlling the consequence part of it. I wanted to get involved more in the disputes when they are at the initial stages. So that's why I moved into the in-house sector. So I joined this legal outsourcing company and started working on large-scale commercial transactions, which had global implications, global approach. I saw the disputes at birth there, right? And then eventually I moved into security service industry, as I said, and I further developed my understanding about how the regulatory issues are coming up. One single ambiguous definition in a contract can lead to years of exposure, right? So that's when I started understanding things more fundamentally. When I moved to oil and gas, that sharpened the consequence part of it. Because here you work with the government counterparties, you are working on rigs, you deliver equipment, you supply personnel, they perform in high risk area. So the financial and operational part of it becomes very important. You understand that the implications can be really strong. That theoretical legal approach would not work in that circumstances, right? So we need to understand how your actions, how your advice is going to give out a financial implication for the company you're working for. So yeah, it changes your perception about the risk, how you understand the dispute, how you manage disputes from litigation to moving in house.
Very true. And I think oil and gas as an industry is ever dynamic, I believe. Every day prices are changing. Every corner of the world will bring some implication and some impact on your trade to go about it. We are in middle of a war time right now where one region is experiencing war, and that region is known for, Iran is known for oil reserves that ways. And I'm sure that has great implication on oil and gas industry. What's your take on the ongoing scenario to oil and gas industry pertaining situation?
I think whenever situations of these kind arise, of course, I mean, oil prices, they are affected. But what I've seen, I mean, not only this war situation, you remember COVID, right?
Yes.
So whenever these kind of events come up, which we lawyers call as force majeure, right? So things change dramatically. The risk that we understood while we get into the contracts, they change completely. Your financial implications change, your budgets change, your revenue targets change. Then it also has a downstream effect on the other industries, other sectors, right? Oil and gas is one of the basic ones which kind of helps determine the overall prices of commodities globally. Whenever these kind of situations arise, of course, oil gets affected. Companies like Weatherford, we also get affected. I'm sure the other place in industry are getting affected as well. Not only the equipment which are going to come out of Middle East or the oil supply which is going to come out of Middle East gets affected, but if you're having things coming from US, right, or any other region in Europe, and they are routed through Middle East, they get affected as well. So it results into quite a significant impact on both your operations and on your finances.
Agreed. Agreed. I think there is some uncertainty now with the situation, but I hope we overcome this scenario and we get back to the routine soon as possible.
Let's hope
And I hope it prevails upon this better sense prevails upon all the leaders who are causing these kind of situations.
Absolutely.
So, Vipul, early in your career, what was your biggest misconception about how disputes actually unfolded? And what are the real world examples or experiences that corrected it permanently for you?
Early in my career, I used to believe that the disputes are all about legal merits. The side which has better legal arguments will be the side which will win.
Okay.
Experience corrected that very quickly, right?
Okay.
Legal disputes are not only about legal merits, they are important, yes, but it is only one of the components. The tribunals, the courts, they also look for documentation, they also look for positioning, timing, narrative control. I've seen very good cases getting diluted because the documentation trail were inconsistent. But I've also seen weaker cases settling favorably because the timing, the positioning was good, and the risk perception was managed, right? In terms of the on ground dispute part, as I said, I mean, so once you get into it, you need to have a coherent story to present before a tribunal, right? Your legal teams, your commercial teams, your technical teams, they all need to present one consistent story. That's what the tribunals are looking for. If you are able to present that, then of course the leverage follows, right? You're able to create that perception early on in the minds of the judges and the arbitrator. And as Sun Tzu said in Art of War, you can win the war even before it starts, right? And that thing in arbitration is all about documentation control and narrative.
Very true and very powerful quote, Vipul, that you quoted. I believe, in my experience, when I started as a litigating lawyer in career, many a times we were only focusing on what is the meritoriousness in the case that is favoring us. Very rarely we were worried or concerned or used to start thinking, as you mentioned, that the whole coordinated act and making it sure that each and every stakeholder from your side is speaking the same you know aspect or case or merit wise or factual information, and narration needs to be well synced. It's very true, and I think there is a great sharing on this. The strategy helps you in winning these kind of situations, and strategy involves these scenarios, positioning, leverage, and optics that you need to present while you are defending or presenting a claim to go upon.
Absolutely.
Very true. Thank you so much for that take. Moving to the next question, Vipul, which is linked to this aspect to go about. Many believe disputes start in courts or arbitration, but as you said, when there is a dispute, there is a strategy to deal with that. But the inception point, if you have to talk about, from your experience, where do the disputes really begin? Is it in contracts, in emails, in operational pressures, or marketing or sales targets or leadership decisions? Where do the disputes really begin?
See, disputes begin when clarity ends. That's the most fundamental thing I believe in. It can be anything from what you said, from contracts to emails to operational pressure to leadership tone. Let's see, contracts create structure, emails create interpretation, operational pressure creates shortcuts, and leadership tone determines if those shortcuts would become normalized, right? And I believe the most underestimated point where the dispute begins is operational pressure. This based on my personal experience for sure. When you sign a beautifully drafted contract, everything is going fine. But then the commercial teams get under delivery deadlines, when verbal assurances replace written clarity, when informal commercial understanding are not captured in the contract, right? That's where the disputes are germinated. Both sides end up believing, when the expectations diverge, both sides end up believing that they are right. I don't believe that majority of the disputes are born out of malicious intent. That's not the case I've seen. They are born out of incremental ambiguity. And that's why I firmly believe ambiguity today, arbitration tomorrow.
Very well put there. I think many of our assignments or disputes that we end up looking at, we are trying to find that ambiguity as a first exercise. And rightly said, with clarity, you can address a lot of things upfront. And if there is more and more ambiguity coming in, the side arrangements, side letters, the verbal assurances, the tweaking that you do or adjustments that you end up agreeing on some corner of email or some correspondence ultimately gets knocked out in the litigation or in arbitration. That puts a real question mark on how the functionality of the company is, and operational pressure is most of the times is underestimated. You rightly pointed out that. Well, I think if all the stakeholders are synced with legal departments also when they are operating certain things, to understand how ultimately this is going to be read out or shown in the litigations, it can attain its actual value and significance while the operations are taking place.
Absolutely. And the example that you quoted initially about the situation in Middle East right now, that's the perfect example of operational pressure, right? Right now, I think majority of the companies who are working in Middle East or somewhere directly or indirectly connected to Middle East,
Right.
they're all facing operational pressures.
Very
Right? And that's are the likely scenario when things can go wrong. And this is where the companies like us, not only in oil and gas, in any other sector, we need to be extra cautious. We need to be in touch and in collaboration with the on-ground technical and operational teams, because that's where the time when the shortcuts actually happen, right?
Right. Thank you so much, Vipul, on that take. Moving to the question that is more to do with you looking your role not just as a lawyer and legal professional. Sometimes you have to step into slightly different roles. Now, because you are part of a big business, you often function not only as a legal counsel but also wearing a cap or role of a business operator with a legal lens. So when did you first realize that legal advice only matters if there is a tangible change that it is coming with as an outcome?
That turning point came very early in my in-house career. So there was a time I remember I was asked to draft a legal note. I did that and I believe that it was flawless. It addressed every legal angle, all the relevant statutes, clauses, everything. It was thought, it was correct. But the business chose to ignore it completely.
What?
I'll tell you why. It was a powerful lesson for me. And I asked myself, why did that happen? And I quickly got the answer. If the advice is purely legal and it is not converted into the financial or operational impact for the business, they would just ignore it. Whenever I would now draft a legal advice, I would think as a business head, if I'm the one who is reading this, will it change my decision? Will it alter the trajectory my business is going? If the answer is no, this means that the legal advice is incomplete. The legal advice should not only address the legal questions, but it also should address the commercial realities. It should also address the operational outcomes. If it happens, then the advice is complete. If it is not, and your advice is not changing any decision making process, you are there to only observe, not to influence.
Wow, this is very important, I think, because professional like us, when we enter into in-house role, probably the initial understanding could be that we are supposed to look into only legal aspects when they are presented. That's a kind of a blindfold view to go about. I think what you mentioned means you need to be well synced with other parts of business.
Right.
Functionality, you need to know what's happening there. That means you need to have conversation, communication, you need to know about the industry, not just what is being floated in the company, but also outside in the world that is happening.
That's true.
So, people will move to a little bit of actual arbitrations and court matters pertaining experience of yours. In recent multi-million dollar arbitration matter that you led, what is a single strategic decision that shaped the entire matter from evidence strategy to final outcome?
Sure. See, if you allow me to not go into the confidential part of it.
Absolutely.
So I believe the single most important strategic decision was that we chose to build internal coherence before we pursued external aggression, right? So when these high cost, complex issue they come in,
Hmm.
the legal teams are under very high pressure to respond strongly and immediately, right? But in that particular scenario, we deliberately slowed down. We did the opposite. We first built the internal coherence. We understood what the matter was actually about, right? Every single team who was involved in that particular matter, be it again the operations or the finance or the legal or the logistics, everybody came together. We understood and we mapped the operational timelines versus the contractual milestone. Once we had that internal coherence, internal commercial narrative, then we pursued the external aggression. If you don't build that, the tribunal will not have a consistent story to follow. And that's very important, at least what I've come to understand over the years. The tribunals are not looking for theatrics, absolutely. They're looking at which side's version of event makes more commercial sense. And once you're able to present that, once your legal, commercial, technical teams are speaking one language, you are able to build that coherence. You're able to build that perception. And when perception stabilizes, that leverage automatically follows.
Very true. I can totally relate to this aspect, Vipul, because recently we represented a company in an international arbitration, and we were dealing with a counterparty from China. And naturally, it's an international arbitration, and we had a third-party country-based arbitrator. And the approach that we adopted was more or less like what you described. We had all stakeholders in preparation stage with us. Expert witness were brought in. The counsel that was representing us was involved right from the stage of invocation of that arbitration till the every last bit of evidence and questions that we are preparing to be asked to the witnesses. So whole exercise and participation of all the stakeholders from our client side was really, really helpful for us to not only present our case effectively, but also defend all the claims that we put against her as a counter.
Absolutely.
And we managed to get a very successful outcome with all the costs and everything that was given to us. And what we experienced from the other side was in the life cycle of one arbitration proceeding, they had to change law firms 3 to 4 times.
Okay.
And, ultimately, when we are looking at the cost part, the reason why we also got awarded the entire cost of arbitration as well as lawyers and all the expenses, because the counterparty ended up creating a cost for themselves which was 5 times more
Wow.
than our cost. And the arbitrator says that if the respondent can afford this expenditure, they can very well cover expenditure of the claimant to go forward. So I think this well synchronized act is also allowing you to bring down the cost and bring the best output for you to go about.
Absolutely, absolutely. And that's where the experts like yourself help our companies, right? So I mean, yes, of course, we can build our internal story perfectly. All the departments are working together, but then our version might be biased, right? So experts like yourself, then you'll come in and you'll stress test our version of the story, right? Before the external parties can exploit them.
With for all good intentions, for good
Absolutely,
reasons.
absolutely.
Yes.
Yeah.
Yes. Great.
See, it's a again. I think Abraham Lincoln said, right? You give me 6 hours to chop a tree, I would spend the first 4 sharpening my axe, and that sharpening axe is nothing but documentation, discipline, and narrative control.
So moving from the arbitration to a processing stage where you are in part of a larger bidding process and there are multiple bidders to go about. In that specifically in situation about convincing a public state undertaking to alter their bidding terms
Yeah.
is something which I have not heard, honestly speaking. This is something very rare for me. So what did you really change? Was it the legal interpretation? Was it the data narrative that you put forth, or the organization's risk perspectives that you kind of shared with the PSUs?
No, you are absolutely right, Rahul. Having a PSU, in our case, working for an oil and gas company, the national oil companies, for any country, not only India, for any country is very rare, right? And what we did change was the perception of risk. When you are working with these big players, right, who are settled in this industry for decades altogether, you know that legal arguments would not be able to change any minds. What does it matter, right? What you need to tell them is that the change they are trying to bring in is not only correct from the legal argument perspective, but it also strengthens the whole process. Now, I'll give you an example. So, when we reach out to any PSU for that matter, we don't present the story as this is unfair to us. No, that's not how we approach them. How we approach them is that if you continue doing what you're doing, somewhere down the line, the contract may become ambiguous. Your bidding process may result into reduced competition, unnecessary, unavoidable complexities. That's how we present the whole thing. These PSUs are the guardians of processes, right? That's how I see them. If you're able to show them that if a calibrated adjustment would strengthen their process integrity, that resistance reduces. You cannot change anyone by proving them wrong. That's not how it happens. But you need to tell them that their organization's interest is actually aligned with yours, and then it flows down to the contractual rationality. That's when the change happens. Influence in these kind of scenarios, it is not imposed. It is built over time. Patience is very important in these cases.
Wow, very interesting take on this scenario, Vipul. Generally, when we interact with some of the companies, even we try to do a bit of that, what you mentioned, but not in that great sense and may not be with that kind of patience level, to be honest. We believe in when we are in negotiation stage with our clients for any kind of work, uh, we try to share the realistic consequence of not doing things in fullest legal sense to go about. So, and we being the external lawyers and law firms, we have understanding of situations like arbitration, situations like government actions, situations which can suspend or delay the initial processes of you
True.
kickstarting your project and all. And from the size of company and from the size of market, we try to give a estimate of this is the potential loss that company may experience, the corporate may experience. This is my learning from a concept called sell the loss.
Right.
Because
Yeah.
what you are showing them is an actual scenario. You're not trying to scare them, but you're giving them a understanding. And again, not trying to convince them. This is pure sharing. Because again, we don't to convince them that why our professional services are much needed for them. But we also want them to be mindful as to, if not us, to someone else, at least they should go and take that legal service, because otherwise these kind of losses are seen in situations and litigations and courts to talk about. And if you talk about one arbitration, in India, arbitration is cost wise, resources wise, time wise, so consuming. And if you happen to have senior judges and all, their availability is also a challenge, because of which, without anybody having a bad intentions, things get stretched over the period of 2-3 years.
Yes.
And then the appeal stages are a different story to talk about. So very true. I think these sort of alignment is needed. And if you are able to do it with PSUs, that's a great achievement. Congratulations on that.
But again, it's very rare. I don't want anybody to have any kind of wrong conceptions that yes, the PUCs are open for change. They are not. It's very difficult.
That's
But yes,
this is first time for me.
yeah, but so again, as I say, you need to make the change feel safe. That's how it goes about.
Perfect. Vipul, you've received CEO award in your career for resolving a complicated, sensitive trade union issues. What is it that you managed to achieve from this, and what is the outcome, the impact that you managed to create to get this kind of solution and the well-deserving award?
Thank you for that. See, I think in this particular case, the issue was, of course, sensitive. And what stood out the most for me was the impact the whole resolution had, right? Now, the trade union issues, these human issues are, of course, they are legal and compliance matters, but there are also human element to it.
Agreed.
Right? They involve dignity, morale, operation shutdowns, prolonged unrest. It can be anything. The escalation risk is quite high, right?
Very true.
So what you do here is not to just handle this as a human issue or as a legal issue, but to find that delicate balance, right? Legal processes can be clear, right? For a country like India, of course, there are circumstances when the matters can get very complex, but in my particular case, the legal process was quite clear. I know the law has already set boundaries for me. What I needed was a proper communication that stabilizes the whole thing. I learned that in these kind of issues, temperature management is also as important as legal positioning, right? These kind of trade union issues, they're about communication gaps. They're about breakdown of challenges. The channels that the employees have, and the perception that the workers end up having is that the institutional is detached from them. They don't have anywhere to go.
Right.
That's how these issues start coming up. So the more you engage in engagement or dialogue, that's when you start addressing the issues from the core. In this particular matter, I think the best outcome was that the restoration of trust across levels, not only the workforce, across management, across leadership, right? That's when you feel the actual impact which comes out. The CEO award was appreciated, of course, but the restored balance, which had a deeper contribution.
Very well put. I think temperature management is the critical thing that you highlighted. I think it starts from there. The aggression that unions generally come with, if management decides to do a tit for tat kind of scenario, it's just going to become worse. Most of the times it happens, unfortunately. But if good communication and ultimate objective of restoration of trust is maintained as a focus approach from management, as well as some of the leaders of trade unions also, if they are aligned to this, then you can definitely reverse the situation. And you're given a perfect example of that, Vipul.
See, you're absolutely correct, Rahul. So that part needs to be handled very delicately. You cannot over-compromise. You have to find that delicate balance because you don't want to strike this rinse as well, right? So you have to protect the company's interest as well. So while maintaining your legal boundaries, if you can introduce that empathy in this whole issue, the outcome is favorable. It's win-win for both parties.
People across the sectors that you work, be it from legal processing outsourcing to security and facility management to oil and gas, and this is not just one location or one country, multiple countries, like you just narrated 7-8 countries
Yeah.
uh, in our opening part. So which role and matter or transaction gave you the deepest professional satisfaction, and why did it matter beyond the headline win that generally companies or professionals go for?
See, I've come to realize working across Asia, Middle East, and all these jurisdictions, and having lived in Middle East for a while, the deepest professional satisfaction comes from the matters where the organization resilience is improved. Right, winning a argument is fine.
Hmm.
Getting a successful, favorable outcome in a large-scale arbitration, of course, is satisfying. Convincing an opposite party to revisit their rigid contract terms is
Hmm.
rewarding for sure. But what actually matters for me is when the company emerges stronger, right? I'll give you an example. There was a contractual exposure, cross-border contractual exposure, very high value, very complex. And what we did eventually was we came out with stronger internal review protocols.
Mhm.
We improved our documentation discipline. We improved the collaboration between the legal teams and commercial teams and operational teams, right? If you are working across Asia and Middle East, you know how the regulatory and compliance scenarios differ, right? So you are able to build out systems and processes which can outlive any dispute. That to me is the more satisfying thing. And see, the best way to predict the future is to create it, right? So I think the preventive architecture is always better than defensive success. Where if you're able to better your organization, that will create a far better impact as opposed to any isolated victory.
Very true. And I believe a lot of corporates are adopting that process and approach now. Prevention is always better than cure, saves time, energy, resources, and you use your resources for much better and positive scenarios to go for. Looking at this approach and all, Vipul, I would like to understand the legal philosophy that you believe that as a role of a lawyer inside company, one should, adopt and move with.
Mm-hmm.
So, in one sentence, if you can describe the philosophy of a lawyer in a company.
Just one sentence.
Yes.
It's very difficult. Okay, but if I actually have to distill it into one sentence, let's see. I'd say the role of a in-house counsel is to make the risk visible early enough that the management is able to take intelligent calls before the accident happens. That's how I would want to put it. I think we discussed earlier that the legal disputes are rarely accidents. They are chain reactions. They can result from ambiguous drafting, process gaps, misaligned assumptions between the team, lack of documentation. It can be anything. But those early signals are always there. So as a in-house counsel, as the function, as the support function, you need to be there to understand the commercial implications of it, right? The advice is not only about what is right or what is wrong legally, but you need to turn that into consequence part of it. Can it result into any financial impact?
Mhm.
Would it result into any supply chain disruption? Would it have any compliance implications? Once you're able to present that, the surprise element goes down. And to be honest, what I've seen is that the management, the leadership avoids and they don't really want any surprises with their business. Risk and growth go together. I don't believe any business, I mean, it can function without having any element of risk, right? Risk will always be there. What in-house counsels do is to calibrate that risk. You translate that risk into financial and operational outcome. Once you're able to do that, you become a credible business partner for the business.
Very true. I remember recently I was part of an event and the keynote speaker happened to give this one statement that he has 22 businesses, but in real he's into only one business, risk mitigation. If he is doing that successfully, he can add more businesses under his portfolio and kitty to go about. So I think assessment of risk and making proper planning before you enter and while you are growing and expanding is most critical thing. And as you rightly said, with all activities, you have to be ready to deal with risk scenarios or take risks to move into different things. And
Right.
company like yours, they are all over the world, right? You're in multi-country presence, so you have to have that willingness and that factor to kind of consider all the moving pieces, that global situations, economy, war times, and changing political scenarios, god foreign policies of every country that is going to bring challenges. So very well put. I think
Yeah, absolutely.
important for many of the professionals who are trying to join the corporates, they should understand this element and angle when they take up any role and responsibility.
True. Very true.
Now, let's try to look at this scenario in a slightly opposite way. For aspiring lawyers who want to become general counsel or in-house counsels, what do they misunderstand most of the time about the role?
Okay, I'll give you with my personal belief when I started my career. I used to think that the GC is the strongest legal technician in the room. It is not, right? The GC is there to set expectations for the leadership, right? And they need to have financial understanding, which they can use to present the real-time risk scenarios to the management, to the leadership. I think they need to have ability to convince the leadership to change their decisions. And finally, they need to have governance foresight. I think, I mean, all these things is what differentiates a GC or an in-house counsel for that matter from the external counsels. Because see, I mean, external counsels again, I mean, they have a lot of oversight. They have got industry expertise, they've got sector-wise expertise, they have got legal expertise, which of course, I mean, the in-house counsel, because if we are working with the companies in like oil and gas or any other sector, we cannot really have understanding about law for each and every sector. So that's why we need to count on people like you, who are the experts, right? But as an in-house role, we need to have better understanding of the business itself. We need to move closer to the commercial conversations, right? While having the legal understanding about all these things. So when you combine these things, you are able to present a better advice. The leadership is going to come to you and they're going to ask you questions. Can we live with this risk? Right? That's the usual question which you are asked. So you'll be able to answer those questions from a legal as well as commercial angle. That's what I misunderstood completely. I thought the GC is nothing but a chief legal officer. Being a legal officer is part of the role for sure. But then we need to move closer to the commercial and operational discussions as well.
Right. Very much needed clarity that one should go with in these roles and understand the expectation that companies are going to have from their in-house counsels and GCs to go about. So thank you for sharing that part. If you think, Vipul, if you could redesign how companies use laws internally, is there any one change that you would design or you would implement?
Let's see. I think yes. I would want the companies to involve the legal department early on when they are structuring any commercial transaction, any deal. At times it happens, and it has happened a few times in my career as well, when the legal is brought in much late in the picture, when the commercial negotiations have already happened, when the operational timelines have been agreed, when the relationship promises have already been made, and the legal comes very late in the picture. So we need to be brought in early when the deals are in discussions, they are at their birth. So we can draft the documentation capturing the actual realities, be it operational, be it financial, be it anything else. Because if you are able to capture the actual realities of the business in the documents, those disputes, those issues later on will reduce dramatically. And if I may, I would also want the legal teams to be present into the business discussions, right? Present their data dashboards about the recurring dispute themes, about any compliance metrics. So have that kind of data available from legal side as well. So the more, again, as I said, the more close we are with the business, the better it would be for the company as well.
Very true. I think in few of our earlier episodes also, Vipul, we had guests and who kind of said the same thing in different words, but the intent and meaning was the same. I think legal department should not be seen as a firefighting department. It should be
Absolutely.
seen as a more of product or positive contributor, and that's why they should be closer to the decision making process or evaluation process, whether to go for the decision or not to go for. And that creates an obvious scenario where legal heads or GCs will end up becoming part of boards. We deal with MNCs, and we see this trend where the head of legals or GCs are contributing in expansions. They're contributing in deciding many of the new verticals, new product lines, mergers, demergers, kind of a technical decision. And they are no longer just there to implement those decisions. They are deciding whether the pros and cons are, allowing or rejecting these set of situations to come in. So very well put and very much needed scenario to be seen in companies.
No, absolutely. I think, we covered this part earlier, but again, since you brought this up, and it's very relevant, and I completely agree with what you said. It's not about firefighting. It's about setting the tone of the company. It's not only about reacting what happens after it has happened. It's also about influencing what is going to happen.
Absolutely. Now, in our last segment, Vipul, we are focusing on cross-border judgment and the future. So, talking about first aspect, having managed cross-border contracts across jurisdiction, what is one lesson that only comes from on-ground experience and not from reading contract?
Interesting. See, okay, let's put it this way. Reading the contracts will tell you what is enforceable, but the on-ground experience will tell you what is practical, right? Contracts can tell you this is right, this is wrong, you can do this is like the right, and this is the obligation, all good. But whether that is going to actually happen, whether it is an operational reality, nothing but the on-ground experience will teach you that, right? Again, having worked with companies and sectors across Asia and Middle East, what I've seen is that the enforcement part of it, it differs quite a lot. And there's a reason to it. The hierarchy in a company, that changes how fast a decision can be made. Regulatory responsiveness differs. Risk appetite differs, right? In one jurisdiction, escalation notice, a legal notice can create difference. In the other jurisdiction, you might need to activate relationship channels before you enter into any kind of confrontational side of it, right? So what I've seen is that the enforcement differs a lot, and you cannot just start quoting the contracts when the operational realities are completely different. For example, if you say that terminate this contract, but the contract has strong supply chain dependencies, or it is with a government body which has got a government project going on, right? The theoretical rights will be overridden by the operational reality. So you need to have cultural fluency and cultural understanding in addition to having a legal fluency. That's what the on-ground experience teaches you.
Agreed. I remember getting a question from my fellow lawyers from Europe. They were visiting us last month, and their question was this only. Yeah. What is the one thing that you would advise foreign companies who are, doing business in India, how to get into business? And I believe I happen to say the same thing. Don't treat each state of India as one country. Each state operates like a different country, and cultural nuances are going to be a critical determining factor. And with that, when it comes to companies entering into India, we are now started first giving foreign companies geopolitical risk analysis report.
Okay, nice.
Which is specific to a region. If anyone is trying to explore Maharashtra as a region with their sector, what is the situation from political scenario, government scenario, employment, business, marketing, the territory or the district that you're choosing, how that district is strategically located, and active in terms of industry or underdeveloped for the industries to come and change things. Obviously, government incentive schemes are encouraging them to go to underdeveloped or undeveloped districts. But this question comes quite often to us, and that's kind of become a routine exercise for us to give geopolitical risk analysis reports. We as a lawyers are contributing larger extent, and we have consultants from other offices to come together to create a comprehensive understanding about the region, about the sector, how it is received, and the past and the history of this region with some other companies from the same type of product or industry, how it has been for them that becomes a good benchmark and good background check that companies can, perform before they start stepping in that territory or region to go.
Very relevant. It's very important. I mean, from Indian perspective, yes, you're absolutely correct. Each state has its own set of local laws, and earlier, yes, of course, in terms of the labor and everything, I mean, states used to have their own laws as well. But not only from labor, human resource perspective, from other perspective as well, with customs, with any state linked incentive scheme. I think that's a very good step. We do the same as well while we enter new countries because since we are a US based MNC and US controlled MSC, there are a lot of jurisdictions that we can't work in, or rather, we need to be cautious to work in. So we approach the experts like you to do the same DD for us as well. But yeah, I mean, it's what you said. It seems very relevant.
And last year, World Economic Forum endorsed this as a must-to-have step in any business expansion thing that any corporate is trying to do. So we see a lot of message coming from global platform also, like World Economic Forum, which is absolutely needed for companies to go about doing it. And I must congratulate you and your team for taking that as a mandatory step whenever you are exploring new territories to go.
Yes, absolutely.
We will talking about the next 10 years. What is the biggest mindset shift in-house legal teams must make to remain relevant in their organization?
All right. See, okay, technical knowledge is becoming increasingly democratized, right? AI is already in. It can draft, it can review, it can redline, it can analyze, it can do anything, right? The relevance would lie when a in-house counsel is able to influence the leadership decisions, right? The relevance would lie when the in-house counsel is able to point out the crisis early on, resource allocation, right? Regulatory exposure for that matter, managing internal politics, right? So that's where the relevance would lie. Again, as I said, it's not only about the legal part of it. The legal counsel is not the strongest legal technician in the room.
Agree.
He is the calmest and most balanced person in the room, right? So I believe, and I personally believe that the relevance in this particular scenario would be for the ones who are able to set the tone in terms of crisis, who are able to act as a translator, a cultural translator for that matter, between the management and regulators, and the persons who are able to manage the leadership expectations as well, while analyzing everything from a business perspective. I think we discussed this earlier as well. We have to move towards the commercial conversation, towards the operational conversation. People who have that kind of understanding should be able to stay relevant. If you're only focusing on the legal part of it, the AI or any other tool for that matter probably will soon replace you.
Then the follow-up question on AI, Vipul, from my side.
Okay.
As AI begins assisting you in many of the activities that you described, with contract, analyzing the risk, assessing the challenges, or even litigation strategies are now generated from AI. Where should the accountability lie when AI generated advices influences a business decision, which later sometimes we see going wrong?
See, the accountability should always lie with the human. AI is a beautiful tool. I mean, I must agree, it is doing its jobs just fantastically. It can recognize patterns, it can draft, it can help you form strategy. Everything is good. But the ultimate ownership remains with humans. If an AI is giving you business advice and it's flagging risks, but the business proceeds with it, the responsibility lies with the business, not with the AI. If as a lawyer, I'm using AI to draft a legal advice and I just follow that blindly, the responsibility still remains with me, the supervising professional. It cannot be passed over to a tool, right? Delegation of responsibility is okay. Abdication is not, right? AI can help you with the workflows, but it cannot replace responsibility. That's what I firmly believe. A day when the software helps you run the organization, that's the day when governance collapses.
Very well said. That brings us to the end of questions, Vipul. Thank you so much for giving clear understanding on how to go about using AI and how mindful you should be when it comes to using AI to taking critical decisions or steps in your organization.
Sure.
Thank you so much, Vipul, for this wonderful
It
sharing.
was my pleasure, Rahul, and it's always great to meet you. It's always great to talk to you because given your experience, I mean, the kind of insights you share about the profession, it's always helpful. For today's session, I hope the discussion we had gives some good insights, not only to the young lawyers, but to people who are actually working in-house, working in field to the companies. And I agree with you. I mean, if it changes one single mind in terms of how legal in-house legal should operate, I mean, I think this discussion would be worth it. So thank you so much, and really appreciate your time today.
Thank you, Vipul. Thank you. It will surely. What you mentioned, it's going to definitely change that.
Thank you very much.
So, ladies and gentlemen, this was a very special episode with Mr. Vipul Dingra, who has shared some amazing insights and much needed facts that legal professionals as well as corporate should understand about the role of general counsel. If you like this content and this episode, please like, subscribe, and share this video with your network and legal professionals and corporates network to go about. And for more, please continue to follow us as we'll be coming with more and more interesting guests. Thank you so much.